Cents Per Mile, featuring Charles Gracie and Paul Gibson, with loads of recruiting and marketing experience and backed by the largest driver audience in the world. We deliver carriers the driver perspective, find solutions, and help make sense make sense.
Welcome to Cents Per Mile. I'm your host, Charles Gracie.
And I'm your co-host, Paul Gibson. What are we talking about today, Charles?
Non-competes?
Non-competes. Oh.
It seems like a fun topic.
Yeah. It's not fun. It's not a fun thing. It's not, but I mean, well, I don't know. I'm curious to get into this because it does, obviously it's had a lot of moments in the trucking industry. But I also think it's really interesting that you normally take the business side of things and I don't. So I'm curious to see where we land on this topic. But
I'm interested to see where I land because our guests that we got coming on are high energy, got a lot of background in this. So who knows where any of us will land by the end of this episode.
Well, I mean, one thing by the time this airs, you landed on Sirius and your show started this week. So that's sick.
Yeah, that's pretty exciting. Monday through Friday, if you didn't hear enough of me talking on Cents Per Mile, you can tune in to channel 146 on Sirius XM between 3 and 6 p.m. And that was my shameless plug for the day.
Yep, you're welcome. Served that up. Speaking of serving up, got to serve the things that we do every episode. So if you listen to your podcasts on Apple Music, Amazon Music, Spotify, you watch them on YouTube, wherever you get your podcasts, we are there. So if you could like, subscribe, rate, it allows us to do cooler stuff, gives us more momentum, pushes us out, gives us cooler opportunities.
You can also go to centspermilepodcast.com. You can suggest a topic to be a guest or even to become a sponsor.
Sponsor? Who's our sponsor today, Charles?
MVT, Mesilla Valley Transportation, starting from loading to unloading, maintaining the highest standards in terms of safety while in transit. They leave nothing to chance. Check them out at m-v-t.com.
Yep, solid people over there. But you know what else is solid this week? Tariff-free news. Let's go.
How'd you find it?
All right, so it's time for 10-2 News, where we look at some of the craziest, most relevant or interesting or whatever tickles our fancy news stories of the last week or so. And so our first one, basically this guy for like on Instagram for his 4 millionth subscriber celebration attached a 6,000-pound plow onto the front of a 1988 Freightliner named Buttercup.
This is awesome. It's major Mad Max vibes. If this doesn't make it into the next Mad Max movie, I'm going to be disappointed.
Yeah. All right. And so, side note, Christian, we will have I will screen grab the video and I will toss it up there. And then we will react to it right now. But if you could cut out the part that I just said, that would be wonderful. You are the man. Oh my God. Did you see the boat? Like it just went through everything like it was a butter cup.
It's awesome. So you see this driver, he's a YouTube content creator, Weston Champlin. It's pretty impressive. Like these photos are awesome. This truck looks fantastic. I kind of want to see it in person. I kind of want to drive it through a couple boats or cars too, suggestive, marketing right here. Would love if you invited me to drive this thing.
There you go. Get him on the radio. Yep. Or on Cents Per Mile. But our next one is a day cab semi-truck left balancing between highway bridges. So essentially they're on May 28th, Interstate 295 northbound near Chesterfield in Virginia. There was a truck. As you can see from the picture, there was two bridges. Somehow the truck slid and the cab went over the side of the bridge, but then caught onto the bridge next to it that was, for traffic going in the opposite direction. Man, could you imagine opening your door and looking down?
No, I'm looking at this photo right now and I'm telling you, this is every trucker's worst fear. You drive next to these barricades all the time. They're supposed to prevent this from happening. And somehow he got his cab over the bridge and stuck between an opening between two bridges. This is like Final Destination's Truckers Edition.
Yeah. I mean, like, how do you even I mean, they don't really. I mean, he was fine. Actually, now that I'm reading the article, yeah, it didn't.
And it's a day cab, so you can't even cry in your sleeper and hide and not look out the window. You're stuck looking down and seeing nothing but
there's
a long drop.
nothing that says I'm not seeing nothing says that the driver didn't make it, but nothing says that they did. Like, how do you get out of that situation?
Well,
You're a Boy Scout. How do you get somebody out of that spot?
You don't. You call your dispatcher, ask for hazard pay, and wait for the emergency crew to come. Because
I guess
the way this. All right. The cool thing is if you're looking at this, you're seeing the frame. You know, obviously the frame is the most solid part of that truck. It's resting on top of the barrier. It's a day cab, though. The only way out is down those stairs, and those stairs lead to the abyss below. I was reading the article, and it said the day cab slid on wet roadway and hopped the barricade wall. You had to be going too fast for conditions. Clear as day right here. You're going too fast for conditions to go that fast, slide, and then hop the barrier wall. Whew.
Yeah. I mean,
it also says it caused a fuel leak and traffic delays. I could believe the traffic delays, and it's since been reopened. No other information on the crash has been released, but
yeah, well, you can see that. You can see that fuel tank got pretty smushed up there.
Could you imagine how this is categorized on a VOE?
I think it categorized under. Hey, we should talk about this one on the phone because I want to know what happened.
Evel Knievel on the day cab.
Call for details. But yeah, so anyway, so the last story, Memorial Day, meat thief makes off with $150,000 in beef as both co-drivers slept. So I'm gonna go on my little soapbox that I do from time to time about drivers getting paid. You know, for their 10-hour breaks. You know, like I always say, like, hey, you know, you don't get paid for that, but like you're still responsible if something happens to your load. This is a great example of that. But they were co-drivers, so there were two of them, and they were both sleeping, and somehow someone made it out while they were sleeping with 10 pallets of beef.
All right, so I get where you're going at. But based on you explaining this, can we talk about the team driver efficiency being displayed here? Like both drivers are what?
I mean, they're yeah. You know, they might stay in the truck. They might have both been, you know, it might have been a 30. I don't know. I don't really know the details. There's possibilities for it, but either way, they weren't getting paid. Because if you're not moving, you're not earning. But at the same time, they're going to be held liable for that.
So it said this happened between midnight and 5:45 a.m. When they woke up, they found that 10.5 pallets of beef had been stolen from the back of their truck.
Yep.
I mean, kudos to them, because I know a lot of drivers that park and never go back to check that seal. You know, maybe it's because they were hauling such an expensive load. But I've slept in the truck. I've been in the cab. If someone's unloading pallets of beef, you're gonna feel that rocking around. I would have at least.
I mean, it wasn't. To be fair, it was a reefer.
Oh yeah, those do kind of hum you to sleep.
Yeah, or you know, that team efficiency will get to you after a while when you finally get to stop. I guess, you know, if all you've been doing is sleeping in a truck and you finally get to sleep in a truck that's not moving. I don't know how it happened, but like, my big reason for putting this one in there is just like, what is that moment like? When you wake up and you're like, oh yeah, man, let's get going, you know, like, or, you know, whatever. And then you walk to the back and you're like, oh, it's all gone. Like
fastest unload ever.
What do you
reefer driver?
What do you mean it's all gone? Well, you know, I mean, I guess lumpers really aren't always free.
Just an idea here. You know, you brought up lumpers. I'm just thinking if they could do this fast, and I've been to some of the reefer facilities and it's an all day endeavor. I'm just saying maybe give these guys a job and we can get the drivers out of the docks faster.
It looks like there was, it says they were asleep between midnight and 5:45. So I don't know that really necessarily speaks to efficiency.
Oh, no, it does. Have you been to some of these facilities? I have.
Yeah.
Man, you can spend anytime I delivered a reefer load, you can be spending anywhere from 6 to 10 hours. And that's if you're on time. If you're late,
Well,
it's
I mean,
rotate you in, and then you're just at the mercy of how well you treated the people that are trying to squeeze you in.
yeah, but I mean that would also be about 6 hours and 45 minutes, so it actually tracks.
Well, it said it happened between that time. It didn't say it took that whole time.
I mean, but it could have.
Could you imagine being the criminal trying to steal meat out the
What
back of
did
a trailer between
what
6 hours and 45 minutes?
what do you put 10 pallets of meat in? Do they have? They would have almost had to have another trailer. Oh, but yeah,
Good job on the news today, my guy.
yeah. Thanks, man. Well, good job on,
Yeah, it's okay.
yeah. You didn't do one yet, but I'm sure we'll do a great job talking to Tenstreet when we go behind the desk.
All right, now that we're going behind the desk, we got Shannon Wheeler, the general counsel for Tenstreet, joining us. Shannon, how's it going?
Good. How are you, Charles?
You know, it's another day, had a long weekend, getting back in the swing of things, and we're talking non-competes.
Yeah.
Yay.
Yay. I mean, lawyers love this stuff. I don't know how everybody else feels, but it's exciting stuff for lawyers.
Yeah. Some enjoy it, some others, depending on where you sit, don't. But it is a hot button topic, and it's been privy to a lot of different vantage points and perceptions to the matter. I mean, you got employees that really feel strongly against them. You got employers that love them, and I think that there's just an understanding of them better. Who better to help us understand from the drivers and carriers' perspective than you guys?
Yeah. Well, great. Well, I'm glad you asked me on and happy to be here. But yes, it's non-competes have become a very hot button issue and more heavily regulated, definitely more governed. And yeah, people speaking up and voicing their opinions. So yeah, I mean, the history for the last year has been really interesting for, again, the lawyers to watch. So just to give a little bit of history for the last year, April of 24, so last year under the Biden administration, the FTC came in and put a blanket ban against non-competes across the nation. It came out with a final rule that said, no non-competes. Companies can't give them to their employees, can't have them sign them. Blanket rule. There were almost immediate challenges to this rule. I mean, on the day that it became final, they rolled out challenges in various federal courts across the country, and that was interesting to see for the lawyers. All the lawyers were, ooh, okay, great. Are they gonna stay the enforcement of this rule? And eventually they did. Eventually, there was a federal court in Texas who issued an injunction saying that this rule could not become effective until the decisions through the courts were able to go through the courts and process those. And so then the FTC appealed that decision, saying, we think that it's a valid rule. We think that we can enforce this rule. The Texas federal court said, no, it's overbroad. You can't enforce this rule across the country in all situations. And then, those got hung up in the courts and the appeals process. And sure enough, in uh, uh, new administration came in and new policies. And on March 7th, the latest is March 7th of this year, the FTC has essentially backed off of its appeal. So it is moved to stay its appeal, meaning it's not challenging the court's decision, and it's not going to try to essentially seek to enforce this ban on non-competes. So I think that's where we're at right now, and there's not going to be any federal enforcement of this FTC ban of non-competes.
So it's back to where we started?
Yes, great. You know so much already. So yeah, you're essentially back to where we were in April of 2024, which is that it's governed by the states, which is sort of an issue, right? I mean, each state, depending on where you're gonna enforce the non-compete gets to weigh in on these. And there are 4 states that completely ban the use of non-competes. So California, Minnesota, North Dakota, Oklahoma, non-competes are not enforceable there. And then there's 33 states plus Washington, D.C. that have some sort of restriction. So it really depends on where you're at. And then even then, there's sort of some additional, salary level thresholds, time requirements, notice requirements, things like that, depending on what state you're in.
That's crazy to me. And as someone that's familiar with the topic, I can tell you I've over time kind of changed my views on it, because if you're ignorant to how it affects people because it hasn't affected you, you wouldn't know. But I can tell you that there's some intricacies with it, because depending on the contract, depending on the business, depending on where you live, there's so many variables to this, how it can impact somebody. It's not as clean cut. So I'm the huge advocate, let the states, people can move to where, their views align with their beliefs and the laws. But in today's world, with a lot of remote work and stuff like that, I imagine this gets pretty slippery pretty quick.
Oh, absolutely. It all depends on the circumstances of the non-compete and the individual circumstances surrounding the reasons for it. So, even among the states that might have a particular rule of law that says they have to have a salary threshold requirement or they have to have notice requirements, there's still courts that are going to look at these and say, well, that might be overbroad, or hey, that was a 7 year time scope. I mean, that's almost unheard of that you would have a 7 year non compete. I've never seen one over 5 years. And then they're going to weigh that against what the consideration was that was paid for it and what the circumstances around it were. So, for example, the sale of a business, if an owner is selling a business, they can almost certainly be tied to a pretty restrictive non compete. They can't go compete essentially with the buyer of that business and start a new business venture. Those are almost routinely held as long as, again, they're limited in time and scope. But just an employee, who works for a company and leaves and wants to get another job, those, courts are going to be really restrictive. Were they, paid a decent amount for that time frame that they're limited? What is the scope of how they're limited? Courts are going to look at those things, even if you comply with the state level restrictions. So it all just depends.
I mean, good thing everyone knows some good lawyers.
Exactly. That's the classic lawyer answer, right? It depends. Nobody really likes that.
It's like the practice of medicine, the practice of law. It's all
Yes,
practice. It's all
exactly.
theoretical until you go to execute, and sometimes it works, sometimes it doesn't. And do you see that these impact drivers at all, from where you guys sit?
I have seen carriers get these. Yes, it's under various different circumstances. Sometimes I wonder if they're just getting what I've heard referred to as a paper tiger, which is really just words on a page that a company never seeks to enforce because they know it's unenforceable. But it's like kind of smoke and mirrors, right? Like you think, oh, well, I'm not going to challenge this. I'm going to rely on the paper, and drivers might not want to challenge it and go work for somebody else. But sometimes, I mean, depending on what they do and what the circumstances are, I mean, they might get a non-compete with a driver and it would prevent the driver just in certain areas or, certain loads for a certain amount of time. But, it underlying it all, it has to be reasonable. And then
So I've
there's
seen
things,
them.
oh, please, yeah.
I was just gonna say I've seen them from the student side. When I was
Okay.
working at a carrier's recruiting office, you would get served with a cease and desist, and it wasn't until that time that I realized cease and desist are, I like that term, paper tigers in of themselves, because people like to send them out there to hope that, hey, that just stops whatever they're doing. And they're not enforced until it's a judgment or an injunction. But you would see carriers send those to prospective new carriers that a driver might be trying to get a job at if they didn't fulfill their student reimbursement contract for the school being paid for.
Yes, I have definitely seen those go out. And I've definitely seen drivers, have those issues. Other things that might not be exactly a non-compete, it might be a non-solicitation. Hey, you can't go solicit our customers. You can't, solicit our employees to another company. Those are all sort of in the realm of restrictive covenants, is the language, the legal language that's used. And I can definitely see those things, and definitely do see those things be used between carriers and drivers for sure.
Yeah, and we're gonna get more into that in our next with our next guest. But it's definitely one of those things where there's layers to this, and having people like yourselves out there to share their information and share their knowledge helps us dissect it and form our own opinion. So I appreciate you taking the time and talking about it with us.
Absolutely. Happy to be on here. It was great to see you guys. And yeah, thanks for having me.
Thank you. So now it's time for Make Sense, Make Sense. And we're doing so with the armchair attorney, Matthew Leffler. Matthew, welcome back to the show.
Thank you for having me, gentlemen. Always a pleasure to be here and talk about the intersection of law and supply chain.
Mhm.
You know, it wasn't until I met you that I saw someone so energetic and passionate about topics that many of us just shied away from because they don't seem fun. But
It is true. Most of the time when regulations pop up, everybody else's face goes,
Yeah.
I think the problem is the way we tell the story, right? These are topics that are very complicated. There's lots of legal mumbo jumbo jargon, terms of art, but I fundamentally believe that if you understand the fundamentals, you can make sense of all of these things. And so my entire career, to an extent, is helping people understand these topics, making them accessible and interesting. If I can't educate you, at least I hope I can entertain you.
You do both.
wow, you just spun regulations to make them interesting. You are a good lawyer, Matt.
That's very kind of you to say. Look, I'm very blessed, right? I've been practicing law for 15 years. I've been a general counsel. I've been an adjunct law professor at a law college, and I teach students and lawyers about what's happening in our industry. And non-competes, or post-employment restrictive covenants, or perks, as I call them, are everywhere. And understanding them helps you navigate not just being an employee, but helps you with your friends and your colleagues and your relatives, because these things are pernicious as they are ubiquitous. They are everywhere. And understanding them is the
you did
first
the lawyer thing. You brought out the big words.
What? Those weren't that big.
No, seriously though, I think it is one of those things. It wasn't until I met you and started hearing this stuff broke down on a normal level, conversational level, that I started to realize that I actually would advocate that these things should be taught at an earlier age, because there's so many people, by the time they learn about these things, they've already signed on something.
Absolutely.
And it wasn't because that they're dumb or they didn't do, they just didn't know. And I think if these things are so life altering, people, it should be part of the curriculum. There should be a general understanding of this stuff at an earlier age before these people go out and sign contracts and have no idea what they're signing.
The numbers are astonishing, Charles. They are astonishing. When the FTC began their research on their proposed rule to ban non-competes, it eventually became a final rule. They began in 2018, and what they learned was about 18% of working Americans, that's about 30 million people, have a non-competition agreement. Now, these are post-employment restrictive covenants. Let me break that down. Post-employment, you do not work there anymore. Restrictive, there is a liberty that you had that you gave up, and it's a covenant, it's a contract. So you have 30 million people that have a contract that says you can't do something for a period of time. Now, were they taught this in high school? Absolutely not. Were they taught this in college? Of course they were not. You can go to business schools and see, hey, do you have any courses on how to negotiate an employment contract? Absolutely not. They do not. Now, non-solicitation agreements, a different kind of flavor of the post-employment restrictive covenant, are even more pervasive. You're talking 50% of the population may have a non-solicit. This is astonishing, these numbers. And so when the FTC decided to make a move to propose a ban of these things, we saw exactly what was going to happen. You look at the comments on the federal rules, over 26,000 people and organizations made comments. And the two comments that mattered the absolute most, the American Trucking Associations and the U.S. Chamber of Commerce. And both of those institutions said, the minute you make a final rule, we are going to sue you. We are going to stop you because you, FTC, do not have the authority. So here's reality. The government is not going to come and save you. No one's going to bail you out. Your job as a worker is to learn what your rights are and try to understand these things. There are more tools at your disposal than there have ever been, ever in history of humankind. So I love this topic because this is not for me and for you. This is for every single American. It is your obligation to understand what your rights are and negotiate accordingly. Now, not always fair. Nothing in life is fair. But this is why this topic is so interesting to me, because it transcends economics. It transcends gender. It transcends ethnicity. This is everything for everyone. And so, again, I get excited about non-competition
I
agreements.
feel like you should be like the lawyer's version of a G.I. Joe poster or Uncle Sam, we want you on this one. No, it is exciting. But one of the things that I've always wondered is why no one has made it kind of more cookie. Everything out there is cookie cutter, but this is one of those things where it's vast. It's broad. There's no guidelines on how restrictive they can be or how defined they need to be or what's allowed or what's not allowed until someone goes to court and has to spend a lot of money just to show that it's unenforceable, which is ludicrous. That puts the burden on the little guy.
Of course, that is the point. It is not a bug. It is a feature of post-employment restrictive covenants. It is a position of inequality when you negotiate these things, unless you have the resources to hire a lawyer. Now, you can see the statistics, Charles. Most Americans, if you had to get $400 in 24 hours, they could not do that. They couldn't get the money. Lawyers do not work for free. We're not pro bono for these types of things. And so you're at a disadvantage negotiating these sorts of things. It is important in the FTC's research that it's like 30 or 40% of all non-competition agreements are workers making under $20 an hour. This is not for executives. We try to convince ourselves this is only for the executives or the super great salespeople. No. This is for everyone. This is for your nurses and your anesthesiologists and your doctors, not for lawyers. Shannon, I think can attest to this. We are ethically prohibited from signing non-competes. That being said,
how do I get on that bandwagon?
You can still get
just got to go to take the bar.
Law school.
If you go
does going to a bar count?
If you're in general counsel role and you sign a non-compete, you are absolutely bound by that. You cannot escape that. Even if ethically you shouldn't have signed it, you are absolutely bound. But generally speaking, we make the rules. And generally speaking, we carve ourselves out.
Yeah. So real quick, I mean, just because, and that is a great overview, but like, so in your experience, because you specifically deal in transportation, what have you seen? How have you seen this affect transportation, like between drivers and or, more on like the logistics side, which I think you spend a lot more time on?
Yeah, that's a great question. I kind of outline it like this. You use post-employment restrictive covenants to protect your business. That's generally the thinking behind it. And to an extent, maybe it drives retention. Like, you're not going to leave because if you do, I might sue you. And so people are less likely. What we find happen is that people are able to change jobs, and most people get raises when they change jobs. If you stay with a company for 20 years, you will never see the kind of raises you will see if you jump every 2 to 3 years. That's just the nature of the world. So in our industry specifically, I see it ruin people's lives. That's what I see. I'm on Reddit, I'm on Twitter, or X as they call it. It's still the Sears Tower to me as well. But everywhere that I go, people will send me and say, I got this cease and desist. What should I do? Or I got a new job offer. Can I take it? And the reality is, even if the non-compete ultimately isn't going to be enforceable, 95% of all litigation never goes to trial. What typically happens is, let's say I'm the employer's lawyer. I send you a cease and desist. Say, stop competing with me. Then I send a cease and desist to your new company. And I say, hey, you have this person you just hired. Did you know that they have a contract with me that you now are tortiously interfering with, this contract? And you know what that new hiring entity does for you, your new employee? They fire you. The entire point of this is to get you out of the workforce, to ultimately keep wages low and drive entrepreneurism down. This is why I want people to understand you should negotiate if you can. And if you have a non-compete, do not sign it. Do not agree. One other caveat I'll mention. Oftentimes, you have a job that you love. And whether there's a change of control or the new management comes in place, says, hey, here's a non-compete, sign it or you're fired. That's what happens. Sign it or you're fired. If you get laid off, that non-compete still binds you. You're not free from that document just because they don't need you anymore. This is why these things are so interesting. They're very interesting. And it's important for people to understand what you give up when you sign that piece of paper.
So real quick, with you saying the ATA was one of the most important comments, what do you, in your just opinion, what do you think the ATA's purpose for like being so defensive about that was?
Because they love them. Again, I want to be very candid. The reason you use non-competition agreements is to keep someone from going out and starting a business, for sure. But really, it's about starving your competitors for talent. That's what it's about. This industry, the transportation industry, is a pennies game. Operating ratio 95%, that means you make 5%. Like, this is not a business where you have tons and tons of money. And so what I look for when it comes to the comments that are made in these public rulemaking is who has skin in the game. Who's going to pay a lawyer or their lobbyist to write something publicly? That is as close to what they truly believe in their heart of hearts when they file these comments. Now, one thing that is super important, and I apologize to your viewers and your listeners, we have to talk about Chevron. I didn't want to talk about Chevron, but we got to talk about Chevron. One of the most important Supreme Court cases happened last year, and that case was called Loper-Bright. And Loper-Bright overturned a precedent called Chevron. Chevron was a 40-year-old Supreme Court case that essentially stood for the proposition: if the statute that created the agency is ambiguous as to what the agency gets to do, we will ask the agency, what is your level of power? And we will defer to the agency. So if the agency says, yeah, I have the power to ban 30 million contracts, we would say, that sounds correct. And then that becomes the law of the land. When Chevron was overturned, that deference went away. Every single one of your listeners and viewers would know the other case I'll mention, which was the OSHA mandate for vaccinations. OSHA came out and said, hey, everybody, you're all going to get vaccinated. And if you don't, you're going to build a testing regime. And America was like, wait, I thought you did ladder safety. I thought you were like fall protection. Like, what are we talking about vaccinations? And it went to the Supreme Court, and the Supreme Court in that moment could have overturned Chevron. They didn't. They found a different way to say the agency lacks the power. So the FTC ban, it is not coming back. I've talked to hundreds of people who think it's still there. It's not, and it's not coming back. So at the end of the day, we have watched an agency try to make a rule that was very popular, but they don't have the power. If you want to see something happen on this, you lobby to your congressional people. There are bills in Congress that actually talk about non-competes. They've been stuck in committee, but there are other avenues. But it is fascinating, man. It is fascinating.
Well, it's one of those things too, where I think that there's a better path, at least from my view as an employee. I think if you can clearly define them, I think whether the employer has to give a little bit of, poster education on what they're signing and highlight that and define it clearly, where the broad ones weren't allowed. I think those things all matter. And I think they speak to a company's culture. If I'm walking in the door and signing one, I probably feel differently about where I'm walking into if I know that what they have on the paper is, hey, I'm going to need food stamps after I leave this job.
There's a couple of regulations I think the FTC could do if they wanted. For example, every job posting has to disclose there's a non-compete. Like, that's one thing you don't have right now. People will go through 4, 5, 6 interviews and never know what kind of contracts they'll have to sign once they get an offer to do that job. If you disclosed you had the non-compete, I suspect people and employees would make very conscious decisions to avoid those businesses. The other pathway I'd say is what Illinois does. Like, I'm an Illinois licensed attorney. And like I said, I've practiced for 15 years. What Illinois does is we have a threshold for salary. So if you're under a certain number, like 75 grand or something, you can't have a non-compete. It just doesn't make sense. And then
laugh at how low that is, though, in today's standards, like 75K.
Well, the FTC
that means that your average truck driver could get a non-compete.
I would say it's generally speaking, skilled trades are not going to be enforceable. If you're a truck driver, if you're a mechanic, if you're a dock worker, you're a roofer, you're probably not going to be banned. That ban probably wouldn't hold up. However, you'd have to litigate that. Who's got $10,000 a month to spend in litigation? Absolutely
That was going to be
no
my
one.
next question. What's the if I'm a listener out there and I want to know, hey, just in case, what would I on average have to spend to get a ruling out of a non-compete? What would that be?
So that's a great question. The answer will be it depends. But generally speaking, a lawyer's rate is going to be between $300 and maybe $600 an hour. It varies based on geography. And to just respond to a letter, maybe it's a 1 hour charge. Maybe it's nothing that significant. If you see adverse litigation, if you go into an injunction or into the chancery courts, you could be spending $5, $10, $15,000 a month. It can be very expensive. $80,000 is not atypical in this space.
And how long does it take for one of these things to litigate out and go away if someone was to fight it through?
I'd say 3 to 5 months, but it can go longer. It depends on how vicious your former employer is. And
I'm
most
doing the
former employers,
math. I need to become a lawyer.
they don't want to litigate. Most employers these days do not want to be in court on these issues. They would be embarrassed, generally speaking. Even if they win, they will deter a lot of future companies to work with them and future employees who want to work with them as well.
All right. So before we wrap up, where can people find you and where can they get more information on this since it's such a top issue on people's minds right now?
I mean, you can find me on Matthew Leffler on LinkedIn or my website, armchairattorney.com. Here's the reality. For general counsels out there, these regulations are not going anywhere. They're going to continue to evolve. Every state will change them every couple of years. So if you have a business case to use non-competes, fine. But if you're a smart general counsel, you will tell your bosses and say, look, do we want to spend thousands of dollars a year dealing with this or just make our company better to work for? Maybe that's a better solution as opposed to suing former people who worked with you.
Awesome. Well, thanks for coming on the show and talk about this and break it down for everyone.
My pleasure.
Paul, that was a lot of information. And I waited till the end because now Matt's gone and he can't say it. So I met Matt in a non-compete situation. I had an employee coming on and there was a non-compete in the mix and they didn't like it. And he actually shed some light to the situation to me where I wound up wiping it down, making it very specific because I actually understood their concern. And I think that's kind of the mentality I think employers need to take to this is you want it to be a positive workplace. You want it to be a culture that you're able to market for your company and bringing new people in. This is a great first step in doing it the right way.
I actually almost called you out for it earlier because I was like, oh, the ban might have dropped, but your opinion did change.
I flipped and it was Matthew that actually helped me on that one. I used to, believe it or not, debate against him in this stuff. There's an episode out there where we debated.
There's an episode out there where you debated me on it. That was probably one of our most heated arguments.
But this is why education matters. I do see the need for them in certain situations, just like I believe in the non-solicits. I believe in this stuff, but only when it's applied correctly. What I've learned is it could actually be applied incorrectly, and there's people that pay the price, and it's often not the company that did it wrong.
Mm-hmm.
So I think there was a lot there, but we got to wrap it up. So thanks for tuning in to Cents Per Mile. I'm your host, Charles Gracie.
And I'm your co-host, Paul Gibson. See you next time.